the application on, among others, the basis that the minister was obliged by law to include the selection criteria taken from the Tourism BBBE Code of Good Practice. In addition, the minister stated that she was entitled to apply such criteria in order to advance the transformation goals of her department. The High Court found that the consideration of race could hardly have created an insurmountable advantage for black businesses over white businesses. The High Court also said that the difference between 2 and 8 points, which represented the difference in the total score caused by the use of the BBBE selection criteria, was capable of being breached by the scoring in other categories in which it was possible for a white applicant to score more points than a black applicant. The High Court further found that the criteria were flexible and that the minister's decision was not irrational. It accordingly dismissed AfriForum's and Solidarity's applications. It also refused leave to appeal. AfriForum and Solidarity petitioned the Supreme Court of Appeal for leave to appeal against the decision of the High Court, which the Supreme Court of Appeal granted. The Supreme Court of Appeal found that the minister had erred in believing that she was obliged by Section 10(1)(e) of the BBBE Act to apply the BBBE status levels as part of the criteria for eligibility for grants from the Tourism Relief Fund. The Supreme Court of Appeal concluded that the minister's decision was therefore materially influenced by an error of law and concluded that the High Court had erred. The Supreme Court of Appeal upheld the appeal by AfriForum and Solidarity and set the decision of the High Court aside. Before the Constitutional Court, the parties agreed that the matter had become moot because the state of disaster had been ended. The parties also pointed out that all the money in the Tourism Relief Fund had been paid out, and nobody sought to have money paid to SMMEs paid back. This was important because the dispute between the parties related to whether the minister had the power to include BBBE selection criteria in selecting SMEs for relief in a tourism relief fund related to COVID-19. The Minister and Director General agreed that although the matter was moot, the court should entertain it because there was a need for clarity on whether the minister had power to use BBBE selection criteria. AfriForum and Solidarity argued that the matter was moot and there was really no need for the court to entertain the matter. This court has concluded that, yes, indeed, the matter was moot and that there were no sound reasons for this court, nevertheless, to entertain the matter, particularly given the fact that its workload had increased significantly since the 17th Constitution Amendment. It holds that it would rather deal with the issues of the powers of the minister to include BBBE selection criteria in the next new matter where this issue will arise. This court said, and I quote, "In my view, there are no sound reasons for this court to entertain this matter despite it being moot. The fact that the High Court and the Supreme Court of Appeal in this matter gave conflicting decisions does not on its own carry much weight. It may have been different if we were dealing with conflicting decisions of different courts in different matters raising the same issue. In this regard, I wish to point out that at some stage in the past, this court may have been more inclined to entertain matters, moot matters, or matters even if they were moot. This court's workload has increased substantially since its jurisdiction was expanded by the 17th Constitution Amendment in 2013. This does not mean that this court will never entertain a matter that is moot if there are proper grounds justifying that it should entertain a moot matter. However, it means that in the future, this court is likely to be less inclined than it would have been before to entertain such matters. This court will, generally speaking, rather wait for another matter that will not be moot before it may pronounce on an issue. This is something practitioners should bear in mind when advising litigants in matters that have become moot. It is not in the interest of justice for this court to grant leave to appeal and determine the appeal. In the result, the following order is made. 1, leave to appeal is refused with costs including the cost of 2 counsel. I hand down the judgments. The court adjourns.
Yeah.